same course as you. I was a lecturer in that course for years.
Yes.
I had to stop, unfortunately. I moved on to other jobs. I would like to welcome you to our library. This is a very special event because we have a course. This is part also of a course, the summer course of the International Institute of Maritime Law. But we also have an audience that is typical of our library talks. We host here tens of events every month, trying to have an exchange on culture, on diplomacy, on issues relating to international humanitarian law, humanitarian relief, and other things that are relevant to the mandate and work of the United Nations. To those of you who came to listen to the debate and the presentation of this important publication, which is in the back for you for free, if I'm not mistaken, I welcome you, and I'm sure you will enjoy having some insights on this very important legal issue. For those of you who are part of the course, and you are basically at the end of it, I would like to welcome you and to tell you that from the perspective of the United Nations Human that I present here today for you, and I know that you visited a little bit, we started this morning in one of our meeting rooms, what you're doing is very important. There are two fundamental enemies to peace that you are fighting, and you are going to be fighters of these enemies. One is chaos. I grew up studying international law, thinking that even war has rules. Yesterday night you saw that some of these rules do not apply in certain contexts. It's okay. But the other one is the erosion of compassion. And I think that people that study like you international law matters should not forget the context and the compassion of which we humans are able and capable, even though some of our fellow humans seem to forget that too easily. So I recognize here Professor Pocard and his very distinguished panel, and I would like to give the floor to our moderator, Professor Veuthey, my friend, my teacher, and then my friend for a number of years, and I congratulate you on another successful course. This is the third time that we host you here at the library. The first time for me is here at the library, and I really look forward to hosting you again next year. So have fun. Michel, the floor is yours.
Thank you very much, Francesco. Indeed, Francesco, I would like to express my gratitude to you personally, also to your staff, and especially to Tess, to Mrs. Castagneda. She has been very helpful in organizing this. Also with my assistant, Guillaume Fournier, who is sitting next to her, and both of them worked very close and very productively. And I must say, what I'm very happy to see is how many people, not only from the course, but also people coming from outside of the course, and including the ambassador of the Council of Europe, and the Deputy Permanent Representative of Italy, and the Counselor of Italy for Humanitarian Issues. Excuse me if I don't recognize other people, but still I will recognize another friend, Vince Sabev, who is Vice President of the Spiritual Appeal of Geneva. And with this, I would like to give the floor to Professor Pocard. Professor Pocard, as everyone knows, is President of the International Institute of Humanitarian Law. He was president, he now is still a judge of He's still a judge at the ICTY, International Criminal Tribunal for former Yugoslavia, was for many years member and also chair of the Human Rights Committee, and is member of the Institut du Droit International. And thank you very much for being with us. After all, you are the president and the chief of the institute, so it's very good that we start with you, please.
Thank you, Michel, and distinguished participants and attendants in this launch of our book. This book is been already mentioned. Is a collection of the proceedings of the annual roundtable of the Institute with little changes. Normally we reproduce the text as a discussion, reflects the discussion we had in Sarajevo every year on important topics of international humanitarian law. And I wish to recognize we do this initiative as of many years together with the International Committee of the Red Cross. This has always been a very not only important but significant and productive partnership between the ICRC and the Institute, and you will see in the book many themes that are themes of concern also of the ICRC, not only of the Institute. The program is normally arranged together, and the speakers are selected together in this exercise as of many years. And we started collecting the proceedings very early, but in different forms. Only in the last 10 years or so, we have this kind of book as you find it now. Now, the topic of the book. The topic of the book is a very classical one, where one looks at the type of the distinction between international and non-international conflict. More difficult is the question, faults, challenges for IHL. Because the distinction is clear in law. The distinction does not present problems as such, although recently kind of conflicts we have now fall with some difficulty in one or the other category. I'm sure that you study law, but if you ask a non-lawyer, as I happen to do, and ask the conflict in Iraq, Syria, and related areas is international or domestic? The inevitable answer of the layperson would be, of course, international. It interests everybody, all the countries are interested. It's clearly international. There are bombings that come from the United States, that come from other continents. It's inevitably an international conflict. Well, in fact, under the categories we have now, this is a domestic conflict, or better, is a more domestic conflict concurrently at the same time, because the definition is that a conflict remains domestic if you have non-state actors combating against the state, and even if the state receives help from other countries, the conflict remains domestic. Of course, if the help goes to the non-state actors, then it's different, because in that case, the conflict will be internationalized, inevitably between the two countries, the two states. But otherwise, and of course, you may imagine this is not entirely satisfactory, because when you go on the ground, it may look more international than it is in doctrine. And that's why some doctrine is trying to find a tertium genus, a sort of transnational conflict. But technically speaking, we are still in the situation of a plurality of domestic conflicts. They go concurrently, of course, so there are links between them that make the situation difficult. And this explains the second part, challenges for IHL, because the trend in some respects in doctrine is to to do without the difference as much as possible. But you know, the law is clear. The Geneva Conventions essentially deal with international conflict, state to state, conflict between states. There is the common Article 3 that deals with non-international conflicts, but it's just an indication, minimum rules of behavior. Then you have the protocols. The Protocol 77, almost 40 years old now, but they insist on the distinction, even more than the Geneva Convention did. They insist on the convention, one protocol. Protocol 1 is on international conflicts, Protocol 2 is on non-international conflicts. So the idea of merging the law, merging international humanitarian law for the two kinds of conflicts didn't work at the moment of the conflict. It was suggested to harmonize it as much as possible, but in fact the states were reluctant because, logically reluctant, because in domestic conflicts they tended to say this is our business, it's not the business of the international community to deal with the conflict, is an internal matter. So they don't want an international discipline of this conflict, tendentially. They are reluctant to have it in any event, as a sort of interference with state sovereignty. When the conflict is international, there is, of course, it's international, there is no problem, because more states are interested, and international law obviously deals with interstate relationships. So there is no doubt that it comes with international law. But otherwise, states showed always some reluctance. It's true that in many respects, and I personally participated in that exercise, courts tend to consider that distinction doesn't work anymore. The ICTY, under the leadership of Judge Cassese at the time, made a big step forward in saying that the regime of grave breaches, which is only in the Geneva Conventions and the Protocol 1, and not in Protocol 2, does in fact apply also for non-international conflicts. I don't go here in how the ICTY in the Danish case arrived to that conclusion, but it's a conclusion that is, does not eliminate completely the problem, in my view, because it's true, it eliminates the problem as far as the regime of crimes, of international crime is concerned. That was resolved, but for the rest, for all conduct operations, other aspects, we remain a criminal code could not resolve that problem inevitably. So there is a trend to put together the law, but it's a limited trend. Now this book tries to deal with this problem and to discuss in a sequence of panels the main issues, because still the regime in the protocols is different, and one has to know when to apply one and when to apply the other. And there are, of course, problems, as I said, of these transnational conflicts that we have now. There are problems of temporal problems. When does, because sometimes a conflict starts domestic, then becomes international. When does it start to be international? Sometimes you have probably intertemporal problems to resolve, and there are a number of issues like the use of force, like the detention, that have to be taken into account. So it's still, although the theme is an old theme and this looks a classical one, in fact is a very debatable theme. And this book tries to bring some clarification on the situation, to discuss problems both in theory and in practice, because when you speak of the applicable law in other conflicts, you have those who have to carry on the conflict and they have to know what to do. So discussing the law without discussing the practice is not not very productive. And the Institute, in all his courses, tries to go also to the practice, but so does the ICRC, to base the development of the law on the practice of science. Well, I stop here, but I think that's this introduction, and leave to my colleagues to discuss other aspects of the law.
Well, thank you very much, Fausto, for this very interesting introduction. And I would like now to give the floor to Dr. Tristan Ferraro. Tristan Ferraro is Niçois, and I would like to extend my sympathy to you, because you just told me your family was close to this attack yesterday, last night. And Tristan Ferraro is Doctor of Laws of the University of Nice, summa cum laude, and actually is now legal advisor at IHL, but used to be in Afghanistan, used to be in Pakistan, used to be in Israel and occupied Palestinian territories as legal advisor. And now he's responsible for legal issues relating to multinational forces, protection of civilians, humanitarian access, and terrorism. But please, Tristan, you have been also in San Remo many times, including at this round table. So, looking forward to listening to you.
Thanks a lot, Michel, for this. And thanks, Fausto, and you, Michel, for the invitation, for having invited the IHC to speak on this book launch. And for this, I just would like to apologize for the absence of Hélène Durham, my director, that would have loved to be there. But within the IHC, we are actually just stuck in meetings discussing budget for next year. And it's really important meeting that she cannot miss. Having been one of the coordinators of this roundtable, having had this privilege last year, as it was the case in 2008, by the way, she felt natural that I would replace her for this discussion today. And what we want also to express is really the continued interest that the IHRC has in having this very close relationship with the institutes. And I think it's very important to continue this collaboration, in particular in relation to the coordination and the organization of this roundtable, because we feel that this roundtable is really a unique setting in terms of IHL. And I think we participate in a lot of international conferences, in a lot of gathering relating to international humanitarian law, but I think besides the international conference of the Red Cross and the Red Crescent, the San Remo Roundtable is really the setting where we can meet the cream of the cream when it comes to IHL in a very conducive atmosphere. And I must say that among the participants and the speaker, we have our counterparts, the state's legal advisor and legal advisor of international organizations. And we are used to discuss with them on a daily basis. But the atmosphere of San Remo is so unique that we can't simply have, besides this discussion within the framework of the roundtable, what is very important is to have this corridor discussion with all this cream of the cream. We meet top-notch legal advisor from ministries, we meet top-notch academic, top-notch people from NGO, just like Anissa, and this creates an atmosphere in which we can really advance the interests of IHL and implementation of IHL. So for this, once again, I think just to underline the importance of the roundtable from an IHRC perspective. And I think this one, the one that we are just discussing today and we're making the launch of, was a particular tableau roundtable for us, because simply it has invited us to explore a topic which is central to the IHRC work, meaning the interaction between and the distinction between international conflict and non-international conflict. And this is a topic which is central for the IHRC because it has a lot of legal and operational consequences for us. Simply because situation of armed conflicts triggers, as we all know, the application of international humanitarian law, and also places the IHRC in a privileged situation in order to carry out clearly the humanitarian and legal work that it has been assigned to by the international community, by the community of states. So this is very important for us to try to delineate the contour of the notion of armed conflict, and this was really the center of the discussion of the last tableau round. and the round table. And as I just mentioned, it's a crucial stage for the IHRC, simply because this topic is at the beginning of everything when it comes to IHRC action and when it comes to IHL applicability. And discussing the beginning and the determination of the existence of an armed conflict, what I can tell you, it's not an easy task. It's not an easy task, and I'm here to witness this simply because within the IHRC, I'm one of those discussing with states whether they are involved or not in situation of armed conflict. And as being a legal advisor in charge of this notion of armed conflict, I'm the one developing the IHRC legal reasoning when it comes to the existence and the determination of an armed conflict, but I'm also the one trying to sell this position with states and with all belligerents. And I can tell you, this is a very, very difficult task, in particular in these current times. And this is a difficult task for various reasons, in fact. And simply, first of all, I think it's important, and I will bounce on what Fausto just mentioned, we need to dispel a misconception in relation to the notion of armed conflicts. And this misconception would be that everything would have been already said and settled in relation to the notion of armed conflict. But the reality is that it's the contrary. When we dive into the subject matter, we know that this is a very intricate matter. Of course, there is a general agreement on the broad definition of armed conflict, be they international armed conflict or non-international armed conflict. We all know that international armed conflict is armed confrontation between two or more states. We also all know that non-international armed conflict is involvement of a state versus a non-state actor, or between non-state actors reaching a threshold of intensity and between opposing parties that have a certain level of organization. We know the contour. But what is very important is try to delineate the content and the boundary of the notion of armed conflict. And this is still subject to very intense debates, not only academic debate, but also I can tell you diplomatic and operational debate. I'm just coming back from a country which is actually refusing the existence of a state of armed conflict in its territory, while really facts on the ground prove otherwise. And by refusing the existence of an armed conflict, it simply refuses the applicability of IHL, and it refuses the possibility for international organization, humanitarian organization, just like the IHRC, to carry out humanitarian activity and to relieve the victims of this armed conflict. So you see the impact of the determination of the notion of armed conflict. And the assessment and the determination of the existence of an armed conflict is rendered really difficult because of the new feature of armed conflicts. In particular, the new feature of non-international armed conflict. And actually, it's not anymore the classic confrontation between states, armed forces, and a rebel group within one single territory. It has been alluded to by Fausto, but no, non-international armed conflict are made of what we call spillover non-international armed conflicts. So meaning conflict starting in one country and spilling over different other countries. The example would be the Mali, where the conflict really extends in Niger, and most probably also in Algeria, but also in Libya. We have also the category of multinational, non-international armed conflict, in which a coalition of states or multinational force come and support militarily the action of all states engaged in an armed conflict against a non-state actor. The example would be Afghanistan, actually. We have also the so-called cross-border non-international armed conflict. It will be the case of, in 2006, for instance, Israel versus Hezbollah, where the state is engaged in armed confrontation against the non-state actors in the territory of another state. And we have the categories that has been underlined by Fausto, the so-called transnational, non-international armed conflict, mainly opposing states, coalition of states, against non-state armed groups, very often designated as terrorist armed groups, for instance. And you have even the worst-case scenario, which is a combination of all the situations. That's the case of Syria, actually, where it's a mix of cross-border, multinational, transnational, and spillover armed conflict. And we, as legal advisor, we have to find a bit the boundaries of the legal framework applicable to this situation in order to persuade the states and the belligerent to respect this legal framework, but also in order to define the legal and operational framework under which we, the humanitarians, are operating in the field. So as I just mentioned, it's a very important but very difficult enterprise. And it's a very difficult enterprise also because it raises a lot of factual and legal questions. And factual question is simply, it's more and more difficult to identify the facts on the ground. More and more, the IHRC in particular, we cannot rely anymore, or with more difficulty, on the web of delegates that we have in the field and that are operating in the field. Take the example of Syria. There is many areas in Syria where we cannot access for security reasons. If my colleagues based in Syria were operating in this area, of course their security will be at risk. So for security reasons, they cannot operate. So they cannot glean, for instance, the information necessary in order to determine whether a new non-state armed group has been created or because it has splintered from other armed groups. So it's more and more difficult to have the factual reality at our disposal in order to make an adequate legal assessment. This is one element. The other element that renders the issue difficult, that's a very difficult legal question arising from this new feature of armed conflict. Not only in terms of personal scope of application of IHL. Who should be considered party to the armed conflict? In a multinational NIAC, when you have a coalition of states involved in the armed conflict, but at different level. Some of them using force, some of them only providing logistical support. Where do we draw the line between those states that are big party to the armed conflict and those states that are not party to the armed conflict? A very difficult issue in our perspective. The same to determine the existence of armed groups. In Syria, we stopped 2 years ago after having listing more than 70 non-state armed groups. Probably there is more than a double, actually. So impossible to make this legal assessment from our perspective. You have also a question linked to the geographical scope of application. Where are the boundaries of IHL applicability? Is IHL limited to the battlefield? Is IHL applicable to the territory in which the armed conflict takes place? Is IHL applicable to the intervening states? So when you have a coalition, just like in Afghanistan, does this mean that IHL also applies to the territory of France, when France, for instance, was involved in the non-international armed conflict in Afghanistan? The same can be raised when it comes to the coalition operating actually in Syria and in Iraq. We all know that some of the acts that have been carried out in Europe in relation to this armed conflict are carried out by people that are either member or at least affiliated to some of the groups involved in Syria. Does this mean that this action in the territory of those states in Europe is regulated by IHL? It's just a question mark. It is something that we actually discuss with states. And you have also another question, which is a question of temporal scope of application that has been raised also by Fausto. When does the conflict start? When does it stop? Knowing that more and more it's difficult to assess this. Because simply you have situations where you have hostilities that stop for a certain period of time and then resume and then stop. There is also a situation where you have a peace treaty which is not implemented in the field. So how do we address this from a legal point of view and from the point of view of IHL applicability? And in coalition, I was just in Belgium discussing with the government of Belgium. They were involved some years ago, 2 years ago in Iraq, and they stopped the engagement saying we potentially could resume of operation in Syria and in Iraq. What does this mean, legally speaking, in terms of IHL applicability? So you see all the difficulty we are confronted with, and I really spur you with the position of states, which are generally more and more reluctant to accept that they are involved in an armed conflict. And this is a crucial issue, because this means that they reject IHL applicability. So this denial of participation in armed conflict is something that we are confronted with more and more while discussing states in particular. We have also the contrary phenomenon. States that are involved in what we call in the IHRC jargon over-classification, meaning that they are claiming that they are in a situation of armed conflict, while in fact they are not in a situation of armed conflict. So for us, their interest being in using the very permissive rules of IHL, in particular when it comes to the conduct of hostilities, but also for the possibility to detain individuals without judicial process. So all this was just to highlight the importance of the topic that was addressed in the round table. And I would just like to conclude But one of the, it's saying that it's very difficult to sum up the quality and the richness of the discussion we have had last year. But from an IHRC point of view, one of the points that we would identify, it's really the fact that the participants and the audience and the speakers never challenge the reality of the continued existence of the dichotomy between international and non-international armed conflict, and really the rejection of the potential existence of a third category which will be situated in the gray zone of IHL. So this is not something that we would accept from an IHRC perspective, the third category, and we will continue to work within the framework of this dichotomy set by IHL between non-international armed conflict and international armed conflict, with all the consequences of this, in particular in relation to the paucity of the rule governing non-international armed conflict. And probably in the discussion, some of you may be interested to know what are the solutions that are actually proposed by the IHRC in order to bridge the gap existing between the rule governing international and non-international armed conflict. Thank you.
Thank you. Thank you, Tristan, for sharing your experience and expertise from the ICRC. And now we have Dr. Anissa Bellal. Anissa, actually, you were also one of the participants, contributor to the roundtable. You are now legal advisor of the Geneva Call, and you are also a lecturer at Sciences Po Paris, and also at the Geneva Academy on Human Rights and Humanitarian Law. And you were also one faculty member of the summer course. So, looking forward for your intervention. Thank you very much for being with us.
Thank you. Thank you very much, Michel, for the invitation. Nice to see those that I met already in San Remo last week. I also want to convey the thanks of the President of Geneva Call, Elisabeth de Warner, who indeed asked me to represent her here today, since I participated in this very interesting roundtable last year on the qualification of armed conflict. So here I will give you just a few insights of how important it is for an NGO like Geneva Call to really understand how conflicts are classified. Because indeed, from a theoretical point of view, all this can seem very abstract. You know, the difference between international and non-international conflict, and you have a lot of theories to tell us how to differentiate between those two. But in fact, as Tristan also said, as an NGO, like any other humanitarian organization, we need to operate against a legal framework. So when we talk to the groups, we need to know whether we are indeed in a situation of armed conflict where IHL applies, and if we are not in such a situation where other legal frameworks apply, and in particular human rights law. And of course, you are all aware that if IHL does not apply, and if it's only human rights law that apply in this situation, then we have a difficulty, because still today there is this controversy that human rights obligations do not apply to armed groups. So, or at least not the whole bulk of it. So, in that sense, it's very important for Geneva Call to know whether or not we are operating in a situation of armed conflict where IHL applies. That said, Geneva Call does not always operate in situation of armed conflict for different reasons. First of all, as perhaps I will come back to it later, but both as Fausto and Tristan said, we don't really know, it's difficult to know when a non-international armed conflict ends. So, and of course we don't have all the presence in the field, and there are different theories that, you know, tell us when a NIAC ends. Whether there is a risk of resurgence of the violence, like you said, with the Belgian government, or you know, when the group is disorganized, or where there is a lull in the hostilities, where in fact the armed group does not fight, so and for a long period of time. So in that sense, can we still say that the armed conflict is existing? And if we do, it's quite important, because and we had a situation like this, in fact, to tell to the group, well, here you are in a situation where an armed conflict exists, so you are operating under the rules of the conduct of hostilities. So principle of distinction, precaution in attack, and so on and so forth, which are the same, thankfully, under both types of conflicts. But if we are not in such a situation, it is more difficult to tell an armed group, well, you know, if you're targeting a member of the armed force and you are not in a situation of armed conflict, then, you know, you are committing murder under human rights law. So it has potentially an impact on the field, and it's a very important situation. Unfortunately, today there is no authority which tells us really clearly in which situation we are, whether it's an IAC or whether it's an IAC. Of course, we turn to the ICRC to have some guidance. We also turn to academic research. At Geneva Code, we do our own assessment if we have reached such a situation. It's not always easy to know when you are in a situation of NIAC, when exactly the threshold has been reached, to what extent the group comes really organized, what type of organization is really required in order for IHL to apply. And all those questions have been addressed here during the roundtable, and we'll find in the book as well. So, apart from operational issues, why is it also important for an organization like Geneva Code, which engages armed groups, to know whether we are in a situation of NIAC or IAC, or international armed conflict? Well, the big difference is that under NIAC, you don't have POW status. So in fact, when you talk to the armed group, it can become a little bit delicate when you tell them that they have absolutely no legal status under an IAC situation. Whereas under IAC, in one case, when you are in fact in a situation of national liberation movement and you fall under Protocol Additional 1, then armed groups that can be qualified as such have the possibility to be granted prisoner of war status under Protocol 1. But this exists only with regard today with one single armed group, which is the Polisario Front, who has made the declaration last year and was accepted by the depository. And when you talk to the group and you tell them that in fact their struggle is different from a national liberation movement struggle, and that their struggle falls under Protocol 2 and not Protocol 1, well, they just don't understand. I mean, for them, I had really the situation where I was explaining this to an armed group coming from, well, I can't say coming from where, but for them, it was a national liberation movement, and their struggle would go back from many centuries, and they were saying, no, but our struggle is exactly the same. So sometimes for our group, talking about qualification is difficult to understand. And as Fausto said also, what is happening in Syria, and trying to tell them that this is a NIAC, it simply doesn't make sense, having all the international states acting in there. And in fact, contrary to what you just said, Tristan, that some states, many states, are very reluctant to admit that there is a situation of armed conflict taking place in their situation, many armed groups, it's exactly the opposite. They claim to be acting in a situation of armed conflict for different reasons. They also are not so reluctant, in fact, to be bound by IHL, because somehow either they perceive it to be a form of recognition of their struggle, and this is exactly why states do not want to have IHL applicable. We use at Geneva Code the 15 rules that we have been elaborated based on customary international humanitarian law, and those 15 rules are the same whether in an international armed conflict or non-international armed conflict. Mainly those are the rules of conduct of hostilities, rules on treatment of detainees. So those are common rules. So from an operational point of view, in fact, in that sense, what we teach to the armed group are the same whether we are in a situation of armed conflict, of international or non-international conflict. So yes, all that to say that for NGOs, it's really important to continue thinking on how the law applies, how the law regulates a situation like this, and it's a way also to engage with the groups on the correct legal framework. And here, probably one of the biggest challenges, as I said before, is the end of the armed conflict and how we can really continue to engage in our group if all the conditions of application of IHL do not continue, and how we can engage those groups on another legal framework. That is also one of the biggest challenges that we are facing today.
Thank you very much, Elisa. And now we have 10 minutes for question and answers. Who would like to ask the first question? Yes, please, sir.
Thank you very much for the presentation of all the speakers. Generally, it is found, I mean, asking just because you had a long deliberation on this book, distinction between the non-international and international armed conflict. And also, I am working in ICRC in Dhaka, Bangladesh. So I'd like to ask a question that in general to see that the other situation of violence, the states are reluctant to say that this is turning into non-international armed conflict. This is usual for any state that they stand. But is there any outcome of your discussions or deliberations that the IHL, is there any possibilities of application of IHL to this type of situations to compel a state to declare when the threshold comes into reality? Is there any outcome on this in your deliberations? Thank you.
Thank you for this question. Who would like to answer this? Tristan? Yes.
Maybe from an IHRC perspective, I think we are used to be confronted with this situation where states simply deny the existence of an armed conflict. Sometimes it's mainly for political reasons. It's simply because they don't want to give some legitimacy to the government, and what they want is simply to stigmatize the non-state armed groups, and that's what most of the case during the last decades, these non-state armed groups have been referred to by governments generally as terrorist groups. It's simply for political purpose. And our job, the confidential dialogue that we have with states involved in armed confrontation, irrespective of the label we give to this armed confrontation, it's in order to make them accept the IHL applicability. It can be a long-run work, but it's a work that which is always carried out by the IHRC. And there is always a point in the situation of violence that the states are confronted with where they start to understand the relevance of IHL rules. Generally, we see a phase where there is a complete denial of IHL applicability, saying it's a purely internal affair, it's a law and order issue, and it's not an issue that we are dealing with the conduct of hostility paradigm. And more in the field, we see the involvement of military component of that states, resorting to use to rules of engagement that are more and more permissive, and that's where we start to have this dialogue on IHL. And what we try is a bit to demystify the applicability of IHL, and just really to emphasize the relevance of IHL in the struggle that they are actually involved in. And petit à petit, step by step, we see the states accepting the applicability of IHL. Sometimes it's also a question of label. Sometimes simply we don't refer for operational issue to the situation as a situation of armed conflict. But in our legal dialogue with the states concerned, we are simply referring to the rules of IHL without having the label. Because sometimes at the label that scares really the states involved in that armed conflict. Simply because of the label, it would mean for them giving legitimacy to non-state armed group. So once again, it's a long-run work, but sometimes it works. Most of the case, I would say it works, but sometimes, I won't mention those states, it's simply impossible to engage into a legal IHL dialogue with them. And in this case, what we said, okay, it's a law and order issue according to you, so you have to respect the rule governing law enforcement paradigm. So mainly your paradigm will be only human rights and domestic law implementing human rights, but it can't be IHL. You can't have it both ways. You cannot deny the IHL applicability and using the permissive rules of IHL.
Thank you very much. And now, Anissa?
Yes, I think it's a very relevant question. That this, from this border between armed conflict and other situation violence. Why? I think it's very pertinent because I believe that today we are witnessing a blurring of what violence is, in fact. Because in some situations you have a very easy spreading of certain type of violence. For example, in the Central African Republic, you had at some point a unilateral huge amount of violence from the Arab groups toward the civilian population, but you didn't have necessarily actual combat between the groups or between the group and the government or another armed force. You have that kind of situation as well in some Latin American countries where you have really a blurring of the violence being used by certain groups or by certain collectivities of individuals. And in that sense, it's becoming more difficult to say, yes, very clearly IHL applies or human rights law applies. It's actually a blurring of a lot of those legal frameworks, IHL, human rights law, and counterterrorism, with regard to the use of force, which is where exactly it matters. What kind of use of force can we use? Whether we are on a counterterrorism situation or which, on our perspective, it should be a law enforcement paradigm, which is more stringent, or an IHL one, which has different parameters. And this is indeed one of the challenges that we are facing.
Thank you very much, Anissa. And now, Mr. Poquin.
Well, my colleagues have already said what I wanted to say. The states sometimes play a game which is the game to apply the rules that are less protective. So when it's more protective human rights law, they tend to go to IHL. When it's more protective IHL, they say human rights law. But the problem is that we will discuss it this afternoon in the course, the relationship human rights law and IHL. The problem is that when a state says, well, this is not a conflict, so I don't apply IHL, but when it's all, but then you have to apply human rights law. Yeah, I can derogate from human rights law because there is a danger. Terrorists represent a danger, so you apply the clauses that allow not to. And the result is that to apply anything. They want to do what they want. To apply violence with armed force without any rule. The idea is no rule. And the same idea, I want to take up a point that Tristan has made before. They came out of the round table that we keep the distinction and don't invent the deaths and ends. Because it's a big danger to do that. Because then you have rules for international conflicts, rules for domestic conflicts, but you don't have rules for transnational conflicts. What do you apply? Nothing. You have to invent new rules. Yeah, but it's better to stick to what we have.
Thank you very much. So, and now, last question. Is there a last question? Oh, yes, please.
Hello, thank you very much for your very enriching interventions. I myself am I'm a law student, currently interning at the UN Office for Disarmament Affairs. And since we're in the middle of a discussion on the applicability of international humanitarian law, this question might be a little bit off topic, but I was wondering whether throughout your research in international humanitarian law, have you ever sought contemplate whether current IHL could cover the use of new weapons technologies such as lethal autonomous weapon systems or robot killers, or should an expansion of IHL be foreseen in the future? Thank you.
Thank you very much for this excellent question, and I think Professor Pocard will give you also an excellent answer.
And I leave the question open, but I would suggest that in September you attend the next round table because it's exactly new weapons. So IHL and new weapons. So this is just a topic, one of the topics to be discussed, and will be in the next round table. It will be too long now to make a long consideration of this issue because there are many. I can give you the program. I mean, the 10th program of the. It's almost done. Of the round table, the topics are well established already, but I hope you can make it because you will have all the answers. All, not really the answers, but the debate.
Thank you very much. And now I would like to give the floor again to Professor Pocard for closing remarks, and actually possibly also dealing with the next roundtable and possibly for an invitation to every one of you to come to this roundtable or to consider that the Institute has a liaison office in Geneva, but headquarters in Italy, in San Remo, and that we do organize not only roundtables but also courses on refugee law, military courses on migration law. Please, Professor Pocard.
Well, I already mentioned the next roundtable next September, which is on new weapons and IHL. That is all the question of the revision of new weapons that unfortunately is not an exercise that all the states do. Let's say that perhaps only a minority of states does it seriously. But there is a rule that inventing new weapons, one has to check whether they are in conformity with IHL and should not be used or productive if they are not in compliance. And you know there are weapons that have been banned altogether, so cannot be used in a conflict, in any event. Chemical weapons, for instance, there is a full organization for that, for checking the non-use of chemical weapons that unfortunately sometimes are still used in some conflicts. So the roundtable will take up a number of questions in this respect, the revision, but also all what happens if new weapons are used, to what extent there is all the problem of new means of warfare, where the question cyber war, for instance, is a weapon, is not a weapon, to what extent is a weapon. There are a lot of issues that have still to be clarified, because you see the law is established in a way, and all we have said that there is a law established, but the law was established years ago, and unfortunately the technological development is such that in terms of weapons, new weapons are produced every day, invented every day. And to apply the old rules is not always easy, but the problem is not to come to the conclusion that the old law, which is based on principles, essentially principles that are undeniable, undisputable, is not good for this. Because if you say that the old law is not good, the result is that you have no law, and you have to go to have new treaties, which will take years to decide, will take years to ratify, and that will be a situation unacceptable, because one has to deal with the problem immediately, now. So always stick to our principles, but adapt them as necessary and find the ways of applying them to the new situation. But I don't want to take too long, and I thank you all for being here, and hope to see you in Sanremo again. Many can be in Sanremo, but to see them again.
Okay, thank you very much, Fausto Pocard, and thank you very much also Anissa and Tristan Ferraro, and thanks again to the library and to all of you for being here. And let's stay in touch. For the summer course participants, of course, we will have the privilege to listen to Professor Pocard on the link between human rights and humanitarian laws this afternoon at 2:30. So, thank you very much, and have a